Okay, I'm reading from the Model Code of Professional Conduct, and I'm picking up in the client-lawyer relationship, Rule 112 through 118 to finish out this section. 111 actually, special conflicts between, sorry, let me navigate there. Special conflicts of interest for former and current government officers and employees. A. Except as law may otherwise expressly permit, a lawyer who has formerly served as a public officer or employee of the government, 1, is subject to Rule 1.9c, and 2, shall not otherwise represent a client in connection with the matter in which the lawyer participated personally and substantially as a public officer or employee, unless the appropriate government agency gives its informed consent and confirmed in writing to the representation. B. When a lawyer is disqualified from representation under paragraph A, no lawyer in a firm with which that lawyer is associated may knowingly undertake or continue representation in such a matter unless 1. The qualified lawyer is timely screened from any participation in the matter and is apportioned no part of the fee therefrom, and written notice is promptly given to the appropriate government agency to enable it to ascertain compliance with the provisions of this rule. C. Except as law may otherwise expressly permit, a lawyer having information that the lawyer knows is confidential government information about a person acquired when the lawyer was a public officer or employee may not represent a private client whose interests are adverse to that person in a matter in which the information could be used to the material disadvantage of that person. As used in this rule, the term confidential government information means information that has been obtained under governmental authority and which, at the time this rule is applied, the government is prohibited by law from disclosing to the public or has the legal privilege not to disclose, and which is not otherwise available to the public. A firm with which that lawyer is associated may undertake or continue representation in the matter only if the disqualified lawyer is timely screened from any participation in the matter and is apportioned no part of the fee therefrom. And D, except as law may otherwise expressly permit, a lawyer currently serving as a public officer or employee, 1, is subject to Rules 1.7 and 1.9, and 2, shall not, Romanet 1, participate in a matter in which the lawyer participated personally and substantially while in private practice or non-governmental employment, unless the appropriate government agency gives its informed consent, confirmed in writing, or 2, Romanet 2, negotiate for private employment with any person who is involved as a party or as lawyer for a party in a matter in which the lawyer is participating personally and substantially, except that a lawyer serving as a law clerk to a judge, other adjudicative officer, or arbitrator may negotiate for private employment as permitted by Rule 1.12b and subject to the conditions stated in Rule 1.12b. And letter E, as used in this rule, the term matter includes any judicial or other proceeding, application, request for a ruling or other determination, contract, claim, controversy, investigation, charge, accusation, arrest, or other particular matter involving a specific party or parties, and 2, any other matter covered by the conflict of interest rules of the appropriate government agency. 1.12, former judge, arbitrator, mediator, or other third party neutral. A, except as Stated in paragraph D, a lawyer shall not represent anyone in connection with a matter in which the lawyer participated personally and substantially as a judge or other adjudicative officer or law clerk to such a person, or as an arbitrator, mediator, or other third party neutral, unless all parties to the proceeding give informed consent confirmed in writing. B. A lawyer shall not negotiate for employment with any person who is involved as a party or as lawyer for a party in matter in which the lawyer is participating personally and substantially as a judge or other adjudicative officer, or as an arbitrator, mediator, other third party neutral. A lawyer serving as a law clerk or to a judge or other adjudicative officer may negotiate for employment with a party or lawyer involved in a matter in which the clerk is participating personally and substantially, but only after the lawyer has notified the judge or other adjudicative officer. C. If a lawyer is disqualified by paragraph A, no lawyer in a firm with which that lawyer is associated may knowingly undertake or continue representation in the matter unless 1. The disqualified lawyer is timely screened from any participation in the matter and is apportioned no part of the fee therefrom, and 2. Written notice is promptly given to the parties and any appropriate tribunal to enable them to ascertain compliance with the provisions of this rule. D. An arbitrator selected as a partisan of a party in a multi-member arbitration panel is not prohibited from subsequently representing that party. Rule 1.13, Organization as Client. A. A lawyer employed or retained by an organization represents the organization acting through its duly authorized constituents. B. If a lawyer for an organization knows that an officer, employee, or other person associated with the organization is engaged in action, intends to act, or refuses to act in a manner related to the representation that is a violation of the legal obligation to the organization or a violation of law that reasonably might be imputed to the organization and that is likely to result in substantial injury to the organization, then the lawyer shall proceed as is reasonably necessary in the best interest of the organization. Unless the lawyer reasonably believes that it is not necessary in the best interest of the organization to do so, the lawyer shall refer the matter to the higher authority in the organization, including, if warranted by the circumstances, to the highest authority that can act on behalf of the organization as determined by applicable law. C. Except as provided in paragraph D, if 1. Despite the lawyer's efforts in accordance with paragraph B, the highest authority that can act on behalf of the organization insists upon or fails to address in a timely and appropriate manner an action or refusal to act that is clearly a violation of law, and 2. The lawyer reasonably believes that the violation is reasonably certain to result in substantial injury to the organization, then the lawyer may reveal information relating to the representation, whether or not Rule 1.6 permits such disclosure, but only if and to the extent the lawyer reasonably believes necessary to prevent substantial injury to the organization. Paragraphs C and D shall not apply with respect to information relating to a lawyer's representation of an organization to investigate an alleged violation of law or to defend the organization or an officer, employee, or other constituent associated with the organization against a claim arising out of an alleged violation of law. E. A lawyer who reasonably believes that he or she has been discharged because of the lawyer's actions taken pursuant to paragraphs B and C, or who withdraws under circumstances that require or permit the lawyer to take action under either of those paragraphs, shall proceed as the lawyer reasonably believes necessary to assure that the organization's highest authority is informed of the lawyer's discharge or withdrawal. F. In dealing with an organization's directors, officers, members, shareholders, or other constituents, a lawyer shall explain the identity of the client when the lawyer knows or reasonably should know the organization's interests are adverse to those or the constituents with whom the lawyer is dealing. And letter G. A lawyer representing an organization may also represent any of its directors, officers, employees, members, shareholders, or other constituents, subject to the provisions of Rule 1.7 if the organization's consent to the dual representation is required by Rule 1.7. The consent shall be given by an appropriate official of the organization other than the individual who is to be represented or by the shareholders. Rule 1.14, client with diminished capacity. When a client's capacity to make adequately considered decisions in connection with a representation is diminished, whether because of minority, mental impairment, or for some other reason, the lawyer shall, as far as reasonably possible, maintain a normal client-lawyer relationship with the client. When the lawyer reasonably believes that the client has diminished capacity, is at risk of substantial physical, financial, or other harm, unless action is taken and cannot adequately act in the client's own interest, the lawyer may take reasonably necessary protective action, including consulting with individuals or entities that have an ability to take action and protect the client in appropriate circumstances, seeking the appointment of a guardian ad litem, conservator, or guardian. NC. Information relating to the representation of the client with diminished capacity is protected by Rule 1.6. When taking protective action pursuant to the paragraph B, the lawyer is impliedly authorized under Rule 1.6a to reveal information about the client, but only to the extent reasonably necessary to protect the client's interests. Rule 1.15 is where I'll stop on safekeeping.